This is Dr.P.Syamala from the Department of MBA at Nagarjuna University. And our today's topic is regarding the procedure for registration of trademark. In previous class, we have learned about the concept of trademark and what are the types of trademark and what are the grounds or conditions for refusal of trademark. Okay, and after that we are going to learn about the procedure for registration of trademark. Okay, so we all know that trademark is a sign or any symbol which is an identity of goods and services which are offered by one person or an enterprise, and this helps in distinguishing them from one offered by another person or any other enterprise. So the basic differentiation that we see in trademarks is it distinguishes one enterprise from the other enterprise, from one product from the other product. Okay, so trademark is we all know that trademark is intellectual property of the user of the trademark, which is the symbol, name, logo, etc. in trade and commerce by the trader. And trademark shows some connection between the mark and the proprietor. Okay, so trademark shows some connection between the mark and the proprietor of the business, which indicates that this product or service is offered by this person, or this product and service is offered by the enterprise. Okay, so this is provided under section 2 ZB. Okay, this we have already learned. And coming to this registration. Okay, so registration of trademarks it will be in trademark office. Okay, we have to register in trademark office, which helps in protecting the trademark of the trader. Okay, so why we have to go for registration means the registration helps the proprietor or the enterprise from protecting from it protects the trademark of the trader. Okay, so this protection may be at national level or international level depending upon the choice of the trader. Okay, so according to section 5 trademark registry. Okay, so according to section 5 of a trademark registry, it was established under Trademark Act previously in 1958. At that time we know that Trademark Act in 1958 we have. So after that this Trademark Act 99 replaced that 1958 Act. So at that time, according to section 5, we have trademark registry. So here only the traders will register their trademark. So the central government decides the head office, where should be the head office of this trademark registry should be. Okay, so if we see in India, according to the Registry Act of 1999, okay, in India we have a head office in Mumbai. Okay, so where are the branches means the branches are in Delhi, Kolkata, okay, Chennai, Ahmedabad. Okay, so these are the branches of the trademark registry, and the Controller General of Patents, Designs and Trademarks is appointed as the registrar of trademark. Okay, so the Controller General will be the registrar of trademark. Okay, he will be the registrar of trademark office, trademark registry. Okay, so if we see why there is a need to go for trademark registration means registering your trademark, it ensures that there is no look-alike impersonating your product or service in the market, eliminating the possibility of having to rebrand. Okay, means other persons, by registering our trademark we are stopping the other competitors or the other trader or the other person or enterprise, okay, to made the look alike product, to make similar product, we are curtailing other person not to manufacture or else not to uh, sell similar to our goods or service. So for that purpose, registering trademark helps the traders. Okay, so it ensures that there is no look alike impersonating your product or service in the market, eliminating the possibility of having to rebrand. So for that, registering a trademark in India is crucial. It is very significant and important if you want to protect you and secure your rights. Okay, so uh, if trademark if we want to say, as it protects the trader from trademarks, okay, by having trademarks from the competitors or the other persons or enterprises. Additionally, this trademark registration also helps customers association. Okay, so customers will have a confidence regarding our if at all a product, if at all a goods or service have a trademark, means it creates confidence in the customers. They will associate with our goods and services. Okay, and at the same time, uh, it nurtures the brand loyalty. Okay, so a distinctive trademark helps customers distinguish your products or services from your competitors. So this helps that your product or else this trademark will enhances the marketability of your good or service. Okay, so if we see, okay, if we see how to register, what is the process for registration of trademark means. So from section 18 to from section 23, it deals with the registration. Okay, so registration of trademarks by the traders or the enterprises. So it starts from section 18, which is apply for registration. This is the first step in procedure. So under first step, section 18 deals with apply for registration. Okay, so if we see, okay, application for registration according to section 18. So if we see, any person may be claimed to be the proprietor. Okay, so applicant may be a natural person, a body corporate, a partnership firm, Hindu undivided family, associations, trust, government body. Any person may be applicant. Okay, any person can be claimed as an applicant. He may be proprietor who uses or proposes the trademark. Okay, applicant means any applicant. He may be the proprietor who uses or who proposes the trademark. And this application, a single application may be made for registration of trademarks. Okay, a single application may be made for registration of a trademark for different classes of goods and services. Okay, so for different classes of goods and services, as I said before in introduction class, there are different classes of goods and services. They are differentiated to register in the registrar office. Certain classes, certain products will be under certain classes of certain classes, and certain services will be classified under certain classes. They will be registered in the registered office. So a single application may be made for registration of a trademark for different classes of goods and services. Okay, and fee payable therefore shall be in respect of each class of goods or services, depending upon the good, depending upon the type of the service. Okay, fee will be differentiated, and according to that we have to pay the fees and register our trademark. Okay, so place of filing application. Okay, place of filing means office of the trademark registry. Okay, place of filing, where we are going to locate our office. Okay, there only we have to register. So within those territorial limits, the principal place of business, where we are, the head office of our business should be located in this registration area only in India of the applicant. Or if in case of joint applicants, if our business has joint applicants means, so in that case, in case of joint applicants, place of business should be mentioned first. Okay, so we have to mention at the time of registration, at the time of application. First, what do we have to mention means, we have to mention about the place. Okay, a place of business. First, you have to mention the where you are going to locate your business in case of joint applicants. Okay, now if we see acceptance or refusal of application. Okay, so see, apply for application. Okay, so after we are applying for application, after we are applying for registration, okay, the examiner or else the registrar, okay, so what does he do in this process? Okay, he may, in this application for registration, he may accept the application, the registrar may accept the application, or he may reject the application. Okay, so acceptance or refusal of application. Registrar may accept or refuse to accept. So if he refuses, what happens means, he will record the reason for refusal. So in previous class we have studied different grounds for refusal, different grounds for opposition of refusal of registration. Okay, so he has to mention on what basis, on what ground he is refusing the application. So he will record that reason. And if he accept means, okay, with or without amendment. So if at all doing some minor amendments to the application, he can register. Okay, so if at all in that case amendment is required means, he will intimate to the applicant, and he will the applicant will amend the application according to the suggestions by the registrar, and he will again go for application. Okay, or else if there is no need of amendment, he can directly accept the application means. Okay, so he may accept, the registrar may accept, or else if he want to change some modifications, if he requires some modifications according to the conditions and limitations, so amendments can be made. And if registrar after acceptance but before registration, okay, finds that application was erroneously accepted, may withdraw the acceptance. Okay, so if he finds any complications in the application means, he may withdraw the acceptance. Okay, so it must be before registration. Okay, before registration. See here, withdrawal of application. So this comes withdrawal of application according to section 19. Okay, so he may accept or reject, or else in this case here, see, if registrar finds that application was erroneously accepted, may withdraw the acceptance. So here erroneously is nothing but the incorrectly. If he received the application incorrectly, or if there are any mistakes, if he find means, okay, so he may withdraw the acceptance. If we see the third step, advertisement of application according to section 20. Okay, so when application is accepted, then he will go for next stage, advertisement. So after acceptance, whether absolutely or subject to conditions or limitations, to be advertised in the prescribed manner. Okay, according to the prescribed manner. Okay, the application accepted must be advertised. Okay, so advertise means, where they will advertise means, they will advertise in the trademark journal. Okay, this trademark office has their trademark journal and website. Okay, they will post in that trademark journal. And what is the purpose of advertising means, the purpose of advertising is to invite objections. Okay, invite objections from the interested persons whose trade interests are likely to suffer. What does this means? See, if I went for application of registration for trademark, then the application is accepted and the registrar went for advertisement of application. So advertisement means they will advertise my trademark in this portal, trademark journal. So whenever trademark application is posted, the trademark, okay, so if any person, if any third party has any objections regarding the trademark, okay, for example, another party, the third party name A, okay, he may object on my trademark, saying that the trademark is similar to his trademark, and he may object, okay, he may object and he may file, okay. So therefore, then if at all the case is valid means, okay, so the registrar will can withdraw this application, okay, so he will cancel the application. So therefore, for that purpose, if at all there are any objections from the interested persons are nothing but the third parties, or else maybe the government also, okay, then in that case, for that purpose, advertisement of application will be done in the trademark journal. Then advertise before acceptance, okay. So advertisement before acceptance if trademark is under some grounds of refusal of trademark, okay. So what does this means after acceptance of and giving of trademarks means we can't do anything, okay. So before acceptance, if there is any objections means on that grounds of refusal, trademarks can be refused, okay. So the application may be refused. So after acceptance or refusal of application, okay, so this advertisement of application can be made, okay. Then if we see opposition of application according to section 21, so as I said, any person within 3 months date of advertisement or re-advertisement within such further period not exceeding 1 month, okay, not exceeding 1 month in aggregate on application in prescribed manner and on prescribed fee allows give notice in writing to registrar of opposition to the registration, okay, if there is any opposition on grounds, okay. In previous class we have discussed the grounds of opposition. If at all on those grounds of opposition, okay, if at all there is any third party entered means regarding the opposition, okay, so within the advertisement will be given, okay, in trademark journal they will advertise. So after advertisement within 3 months, okay, the opposition may be the opposition for this trademark can be filed to the notice, bring notice to the registrar of this trademark, okay. So and this should not exceed 1 month in aggregate means here after receiving opposition, okay, on that within 1 month, okay, they have to pay prescribed manner, the fee should be paid within the 1 month, and they have to give notice in writing to registrar of opposition to the registration, okay. So he after advertisement of within 3 months not exceeding 1 month in aggregate, okay, the opposition applicant, okay, the opposition applicant, he should uh, pay the prescribed fee and he should give notice in writing to the registrar, okay, what is the cause of the opposition in a prescribed manner, okay. Then the registrar, he will send that notice, send that copy to applicant, okay. Here two parties will be there, applicant and the opposition party. Okay, so now opposition party is opposing this person and this applicant. So that that notice, okay, this notice in writing which will be sent to registrar, and registrar will send it to the applicant. Okay, then what should applicant do means the applicant can counter, he can give counter statement. Okay, means that the reasons of that opposition, okay, with evidences, if he has, means he can give the counter statement within 2 months, okay, from the receipt of the notice. When he receives the notice from this registrar about the notice of this objection, okay, within 2 months he should give counter statement. Okay, so if he fails, okay, it will be considered as, it will be presumed, means it will be considered, if this applicant, if he fails, okay, if he fails to say the reasons, if he fails to, it will be presumed, it will be considered as he has withdrawn the application. Okay, he will be, if at all he has not given any counter statement to the opposition party, then the registrar will consider it as he withdrawn his application, the applicant has withdrawn his application. So if at all, if he files counter statement means, okay, then he has to produce any evidence, so which is known as the statement. Okay, he has to produce that statement evidence registrar to the registrar, and who will give opportunity to both them to be heard. So after receiving the evidence from this applicant side, okay, so the opposition party already in writing he opposed the registration by giving notice on grounds of refusal. He gives the reasons also. So for that he also counter claims and he also produces the evidences. So now what should the registrar do means he will give opportunity to both the parties to heard the case. Okay, so after considering their case, registrar should decide whether and subject to what conditions or limitations, if any, the registration is to be permitted. Depending upon the case, depending upon the merits of the case, who should be permitted, either A or either opposition party, depends upon the case. Okay, and subject to the provisions of the Trademarks Act conditions and limitations. Okay, so the registration is to be permitted to either A or to either B. Okay, so after that, registration. So registration according to the section 22. So after accepting the application and disposing the objections, okay, after accepting the application and disposing the objections, if at all there are any objections, means they are also cleared here, disposed, then registrar shall, unless central government otherwise directs registrar with effect from the date of application, the registrar will issue a certificate in prescribed form. Okay, unless and until, if central government directs not to issue the certificate, okay, the registrar according to the application, okay, he will issue the certificate in prescribed form to the applicant regarding the trademarks. Okay, now, so if at all there is default of the applicant, okay, if at all there is a default by the applicant, so the process of registration could not be completed within the 12 months, then registrar, after giving notice to applicant, treat the applications abandoned. Okay, so if at all there is an objection, okay, so regarding that the registrar will send notice to the applicant. So if at all the applicant finds default in counterclaiming, okay, so in the process of registration, if he could not complete the process of registration in proper way, okay, then within 12 months the registrar, okay, after giving notice to applicant, he will give the notice to the applicant after 12 months. Okay, so he will treat the, even though the applicant not responded, means then we have to treat that application is abandoned. Okay, so now purpose of time limit means, what is the purpose of time limit? Why do they keep this 12 months time? Okay, means to avoid delay and discourage non-serious and indolent applicants. Okay, so why they are keeping this 12 months means, if at all in case of a registration or this in this process of registration, if the applicant is not serious, okay, or else to avoid the delay, so in that cases this time limit has been maintained, okay, of 12 months is maintained. If we see what is the effect of registration, what is the benefit of registration means, it will have the validity, okay, according to section 31. After registering our trademark, the trademark will have the validity for 10 years, okay. 10 years of validity will be there. Why we have to register means, already we have discussed that it protects the trademark, it protects the intellectual property of the user, of the trader, okay, of the enterprise. Why? Because from protecting from the other person not to manufacture like that only similar products only, or else not misusing the product of these persons. So effect of registration means it gives the evidence of validity for that trademark, for that goods and services. And if we see the about the renewal, removal and restoration, okay, according to section 25. So renewal means, already we have discussed the time limit for a trademark is 10 years. So after 10 years means, what do the trader do means, he has to renewal his trademark, okay. So renewal means after 10 years he has to do. So the registrar on application within the prescribed period and subject to payment of fees, he will renew after 10 years from the expiration of the original registration or last renewal, okay. When will be renewal done means, there will be a process means, application from the applicant should be sent to the registrar of trademark office, okay. Then within a prescribed period, subject to the fees, if the fees should be paid depending upon the goods or service and the class of the goods and service, okay. So depending upon that, the payment should be made by the applicant for the purpose of renewal, okay, for 10 years. Again 10 years will be renewed. So if it is from the when will be the renewal done means, when it again starts the renewal of the 10 years means, from the expiration of the original registration, or else previously already we have renewed our trademark, okay. Then again after 10 years again we have to renew, okay, we have to go for renewal. So renewal is that thing. So if we see removal, what does removal means before expiration of last registration. So my trademark registration has completed in 2023, okay. So registrar, after expiration of last registration, registrar notice registered proprietor, registrar will give notice to the registered proprietor. So I have completed my trademark last year only in 2023. So afterwards I have to go for again renewal. For that, before expiration of last registration, before expiration only, okay. So in 2023 June my expiration will be there for registration, okay. So before expiration of last registration only, I have to go for application or for renewal, okay. So the registrar, before that only registrar gives notice to the registrar proprietor, intimating him that you have to renew your trademarks, okay. So and a date of expiration and conditions as to the payment of fees all will be sent by the registrar, okay. So if have not been duly complied, okay, with means, then what happens, registrar will remove the mark from the register, okay. So the registrar will send a notice to the registered proprietor about the renewal of their goods or service. Okay, so they will mention about the time, okay, the condition, and about the payment of the fees, all the things. Okay, so even though by receiving that also applicant has not been responded means, then what happens means registrar will remove the mark from the register office. Okay, then provided that fee and surcharge, okay, will be levied on that proprietor, okay, after 6 months, till 6 months, okay, from the last registration. Register again, registrar has to renew for 10 years. Okay, so after the expiration, okay, with the fee and surcharge, within 6 months of that, after the expiration from the last registration, the registrar, uh, by receiving the fee and surcharge, he will renew for the 10 years, next 10 years. Okay, so this is about the renewal and removal. Removal means if at all he the registered proprietor not complied with the conditions according to the trademark office, then the registrar will remove the mark from the register, and if he pays the fee and surcharge within the 6 months period of the expiration of registration, then the registrar will register the trademark for 10 years. Okay, if we see restoration, so what is restoration means, after 6 months and within the 1 year from the expiration of last registration, okay, last registration after 6 months, on receipt of an application, payment of prescribed fee, okay, if satisfied, that is just to do so, registrar shall restore the trademark to the register and renew it. Okay, so within the specified period, if we have not registered our if we have not renewed our trademark means, okay, so after 6 months and within 1 year from expiration of last registration, okay, on receipt of an application, on receipt of an application by the registrar from the applicant, with according along with the prescribed fee, if it is satisfied by the registrar, okay, then the registrar shall restore the trademark. Okay, so after it has already the renewal period completed. Okay, but after completion of the renewal period, so in June month, okay, expiration date completed, last registration expiration date completed, so from June to December, 6 months. Okay, so within this period, after 6 months, okay, after 6 months and within 1 year means again June. Okay, so within this period, again the applicant may go for the application of renewal, the application for renewal of trademark. Okay, so with a prescribed payment of fees, and if it is satisfied with the registrar, then the registrar will restore again the trademark to the register and renew the trademark. Okay, so this is about restoration. See here, if applicant have not complied according to the provisions of the trademark office, if he is not responded, then what do the registrar will do means, he will remove the mark from the register. So after that, what happens means, after removal of the mark, okay, after expiration of the date, after expiration of the original registration or else the previous registration, after that 6 months from 1 year, if he again pays with surcharge according to the prescribed manner, then the registrar will again renew it for 10 years. So that is the restoration here. Okay. So this is all about the procedure for registration of trademarks. Okay. So what is the use of this? What is the benefit, or else what are the advantages of this registration of trademark? Means what does it happens means, uh, it gives registration of trademarks gives exclusive rights. Okay, exclusive rights to the trader or the proprietor or the owner of a registered trademark. Okay, it gives control over it. The owner can use the same trademark for all other products falling under the class or the classes specified in the application, and the proprietor has exclusive ownership of trademark and can restrict others from using it in the classes in which it has registered. Okay, so it also grants the owner to right to prosecute against any unauthorized infringement. Okay, so exclusive rights will be given to the trader. If at all any other person uses this person's trademark, means it comes under unauthorized infringement. Okay, and this owner has every right to prosecute that person regarding the infringement. Likewise, it creates uh, uh, trust and loyalty in the customers. Okay, trust and loyalty. Okay, trademarks represents the reputation and excellence of good or service. So registered trademark develops confidence and recognition among customers in the market. Okay, so having a trademark on a product means definitely it increases the confidence in the customers. It increases a recognition among customers in the market. So it helps in development of loyalty in the customers in long term. Okay, and the customers will consistently pick your trademarked brand. Okay, over others. So, and what else means, it differentiates trademark differentiates the product. Okay, so trademark registration makes easy for customers to find out your product. Why? Because it distinguishes your product or service from your competitors, and all the while serves as an effective promotional tool. So this is because your trademark or logo represents your organization's vision, quality, and one of a kind trait. Okay, so definitely having a trademark means it represents your organization's vision, it represents your organization's quality, it represents your organization's features. Okay, so definitely it will create marketability, differentiation of products, product. Okay, so and what to say means, another one, uh, asset creation can be made. Okay, another advantage can be asset creation. Okay, online asset creation. Why? Because trademarks are registered in online. So the registration of a trademark creates intellectual property for a company, means it is an asset. A registered trademark is a legal privilege that may be sold, delegated, franchised, or economically contracted. Having a registered trademark means definitely that person, the trader, will have a legal privilege. Okay, that he may sell, he may delegate, he may franchise, he may or economically contract from that trademark. And a trademark acts as an intangible asset in the balance sheet of a company that provides all benefits of such assets. Okay, and if we see, it gives legal right also. Okay, registering in the trademark registered office, means in the of trademarks, it gives legal right to the symbol. When a trademark is registered, you may use the symbol on your logo. Okay, to indicate that it is a registered trademark and that no one else can use a similar trademark. Okay, so in the event another person utilizes, if at all, that trademark means without your permission, without your consent, you can sue for such infringement act of that other person. You have exclusive rights of usage in the court of law. So legality will be there, legal right will be there for the trader or owner. And by registration, another important advantage will be there. What is that means? It safeguards against infringement. Okay, it safeguards against infringement. Okay, so no other person can use your trademark. Okay, so if someone uses a trademark without the endorsement of the owner, without the permission of the owner, or makes any misleading utilization of the same, the owner can get an injunction order against the act and stop the individual from utilizing the trademark unauthorized. No one else, including competitors, have right to use your trademarked logo. Okay, so safeguarding our against infringement will be there. And if we see, it will be a low cost protection. Okay, trademark registration means it is a low cost protection, means trademark enrollment is cost effective and allows your company to maintain a distinct brand. Okay, online trademark registration is easy and affordable to maintain. Likewise, when you register a trademark, all you have to do is pay the protection fee and the renewal fee, which is due after 10 years of trademark enrollment. So, as it is an online payment, online registration, online renewal, okay, it is easy for the traders and at the same time it is cost effective. Okay, and if you see, global trademark registration will be there. Okay, global trademark registration. So this is another advantage. If you want to expand outside of India, or simply want to register a trademark in another country, okay, so because a trademark that has already been registered in India, it can be a solid foundation to gain international recognition. Okay, so if you want to enhance your marketability, if you want to extend your marketability, then if you want to enter into international business, then definitely it will be easier if you have already registered in India. Okay, so it can be a solid foundation to gain international recognition. So this is because a trademark that has already been registered in India can be used as the basis for registration in another country on account of all the goodwill garnered here. Okay, then if you see, uh, another important advantage is also there, which is known as you can attract the human resource. Okay, by having trademark registration, okay, it will attract human resource, means popular brands are known for attracting younger talent. Furthermore, young minds want to work for large corporations as it ensures greater perks and more stability. Working in large corporations, it ensures greater salaries, greater perks, and more stability in payment. Okay, so trademark registration puts forth a positive picture of an organization. Having a trademark means definitely it creates positive picture, okay, of that particular organization, and this diminishes the expense of recruitment and other related exercises. So these are the advantages regarding the procedure for registration, regarding the registration of trademarks. Okay, so all this is about the procedure for registration of trademark.